Hi, this is Jenna Scott, and I'm going to be reading out of Carlton Weiss's Concise Trustee Handbook, circa 2008, and I'm about to read the section on prevailing in legal affairs. Here's where we shall get into legal action, the rare instance of public legal affairs, such as determining tax liability, defending a court action instituted against the trust or trustee, and prosecuting a legal action on behalf of the trust or trustee, as well as the possible necessity of commencing a private action pursuant to the commercial process. Boop. Here's we shall get. Boop. Here is where we shall get into legal action, the rare instance of public legal affairs, such as determining tax liability, defending a court action instituted against the trust or trustee, and prosecuting a legal action on behalf of the trust or trustee, as well as the possibility. Damn. All right. Prevailing in legal affairs. Here is where we shall get into legal action, the rare instance of public legal affairs, such as determining tax liability, defending a court action instituted against the trust or trustee, and prosecuting a legal action on behalf of the trust or trustee, as well as the possible necessity of commencing a private action pursuant to the commercial process. The reader must keep in mind that the chances of an action being taken against the trust or trustee who has properly limited his liability are slim to none. And if an action is taken against them anyway, generally such cases don't make it past the crucial phase of determining jurisdiction. When one examines the definition of jurisdiction, the fog begins to clear. Footnote 161. From Black's Law Dictionary, page 855, 7th edition, 1999, the definition of jurisdiction reads, noun, 1, a government's general power to exercise authority over all persons and things in bold, within its territory. And then in triangle brackets, New Jersey's jurisdiction. And then 2, in bold, a court's power to decide a case or issue a decree. And in triangle brackets, the constitutional grant of federal question jurisdiction. 3, a geographic area within which political or judicial authority may be exercised. Also bold. Triangle bracket, the accused fled to another jurisdiction. 4, a political or judicial subdivision within such an area, other jurisdictions have decided to issue different. A political or judicial subdivision within such an area, other jurisdictions have decided to issue differently. Bold emphasis added. There are 2 territorial jurisdictions created by the Constitution. The first is the territory, footnote 162, i.e., that designated portion of the Earth's surface which is deemed the There are 2 territorial jurisdictions created by the Constitution. The first is the quote, There are 2 territorial jurisdictions created by the Constitution. The first is, quote, the territory, footnote 162, i.e., that designated portion of the Earth's surface which is deemed the imperially extensive real estate holdings of the nation over which all power must be exercised within the strict letter of the Constitution. The second is the, quote, other property, footnote 163, i.e., a territory unincorporated, in parentheses, that means not included, into the Union of States, over which all power may be exercised strictly according to the mere, quote, spirit of the Bill of Rights as interpreted by Congress. The latter is subject to Congress outside the strict letter of guarantees of the Constitution and Bill of Rights. In the former, the federal government can have no direct control over the people but by way of contract, because it is entering onto every scene equally subject to the same laws as all persons, as opposed to the latter, wherein the federal government can have full and direct control over people who are beneficiaries of this jurisdiction. As noted earlier, they may act, quote, as they see fit, i.e., as trustees, for the benefit of public policy regulations, known as codes and statutes, of the jurisdiction. Footnote 164. Understanding that most courts currently in business in America are, in fact, by the 1938 change of the operation of law, courts of limited jurisdiction, footnote 165, limited to cases involving subject matter of the 14th Amendment public trust. It becomes clear that whether they are distinguished as federal or state courts, such is a distinction without a fundamental difference. All are inherently federal. In order to get at how such courts may obtain jurisdiction over an express trust or its trustee or trustees in a legal action, the nature of jurisdiction should be briefly but sufficiently examined. First, a court must have three essentials: jurisdiction to determine jurisdiction, jurisdiction over the subject matter of the case, i.e., it must have the power/competence to decide the kind of controversy involved, and jurisdiction over the parties to the case, i.e., in personam or personal jurisdiction to compel the parties' performance. If either one is lacking in any way, the court is without power to decide the case. Footnote 166. And any order, decree, or judgment other than a dismissal by such a court is void ab initio, having only the semblance or appearance of validity. Footnote 168. And any order, decree, or judgment other than a dismissal by such a court is void ab initio. Footnote 167, having only the semblance or appearance of validity. Footnote 168, and may be attacked directly or collaterally and vacated at any time. Footnote 169. It is settled law that a tribunal has jurisdiction to determine its own jurisdiction. Footnote 170, which brings us to the remaining two elements. Subject matter jurisdiction is like the hub around which the wheel turns. Without the hub, the wheel cannot turn credibly. It is comprised of two parts: the statutory or common law authority of the court to hear the case and the appearance and testimony of a competent fact witness, i.e., sufficiency of pleadings. It can never be waived, and it cannot be obtained by lapse of time, consent of the parties, or any event other than the sufficiency of pleadings of the party bringing the suit, i.e., the plaintiff. However, although it may have been established by the pleadings, it can still be lost due to inter alia. Fraud upon the court, footnote 171. The judge's failure to follow proper procedure, footnote 172. The unlawful activity or disclosed control. Boop! The unlawful activity or undisclosed conflict of interest of the judge, e.g. involvement in a scheme of bribery, footnote 173. The court exceeding its statutory authority, footnote 174. Violation of due process, footnote 175. Improper representation of a party before the court, improper issuance of a summons or defective service of process, footnote 176. Proper notice not being given to all parties by the movant, footnote 177. The court is basing its order or judgment upon a void order or judgment, footnote 178, and violation of public policy, footnote 179. And when subject matter jurisdiction is lacking or lost, the court must discharge its ministerial duty to dismiss on the ground on its own motion, whether it has personal jurisdiction or not, footnote 180. Given the preceding sections on the Unincorporated Banking Association under former H.J. House Joint Resolution 192, and all of the above regarding the other property nature of the states today, it is easy to see why these courts are ipso facto courts of limited jurisdiction, having no jurisdiction over subject matter in the capital territory, quote, the territory, capital T. But assuming, for the sake of explanation, that subject matter jurisdiction did exist, then personal or personal in rem jurisdiction over the trust and its trustees can only be obtained in four ways, either by the trusts or trustees, bullet point 1, presence, footnote 182, i.e. it's his being served with a copy of the summons and complaint while physically present in the forum jurisdiction. Bullet point 2, domicile, footnote 183, i.e. resident alone is a basis for exercising jurisdiction. In the case of corporations, i.e. residence alone is a basis for exercising jurisdiction. In the case of express trust, the place of their situs. Permission or consent, i.e. a trustee, either personally or on behalf of the trust, having not been properly served, can nevertheless give the forum court, boop, permission or consent, i.e. a trustee, either personally or on behalf of the trust, having not been properly served, can nevertheless give the forum court permission to exercise jurisdiction. Depending on the act of the trustee, permission can be given well in advance of any lawsuit filed, and the consent can also be implied. And finally, minimum contacts, footnote 185, i.e. having sufficient dealings or affiliations with the forum jurisdiction which make it reasonable to require the trustee to defend a lawsuit brought in the forum state. If the state has no contacts, ties, or relations with the trust or trustees, personal jurisdiction cannot be obtained in this manner. Footnote 186. The four principles of minimum contacts are that 1. The trust's or trustee's activity must be continuous and systematic in the forum jurisdiction, and the cause of action must be related to that activity. 2. Sporadic or casual activity of the trust or trustees in the forum jurisdiction does not justify the exercise of jurisdiction in a cause of action unrelated to the activity. 3. If the trust's or trustees' contacts are sufficiently substantial and of such a nature as to make the exercise of jurisdiction reasonable, then general jurisdiction may be exercised by the forum over the trust or trustees. And 4, if the trust's or trustee's activity is sporadic or consists only of a single act, then specific footnote 188 jurisdiction may be exercised by the forum only when the cause of action arises out of that activity or act. Unlike subject matter jurisdiction, once personal jurisdiction is obtained, it can rarely be lost, and if the trust or trustee permits to make an unrestricted appearance, it cannot later be denied. Contrary to general appearance, which constitutes consent, the trust or trustees may avoid personal jurisdiction by making a special or restricted appearance for the purpose of attacking the forum court's personal jurisdiction, footnote 189, and may even attack, so to speak, subject matter jurisdiction. Generally, a challenge to subject matter jurisdiction constitutes consent, a waiver of personal jurisdiction for the purpose of arguing, but this doctrine does not apply to cases involving express trusts over which subject matter jurisdiction clearly does not exist. Footnote 190. Upon further analysis of the preceding diagram, we see the following. Bullet point 1, presence. The trust is created and functioning in the territory, doing business under the general common law, not the private law of the unincorporated banking association. Presence can therefore only be construed to exist where the trust has become a member of that association via residence in a revenue district indicated by zip code or by engaging in a particular transaction. Even then, the trust or trustee must be present by membership or transaction in that particular political subdivision, parentheses, quote, state, capital S, and given notice, quote, reasonably certain, end quote, footnote 191, to reach them, i.e. service of process via either personal service, substituted service, or constructive service. As service by mere publication in a newspaper of general circulation has been held insufficient in such cases. Footnote 192. And, as a side note, mere physical presence in a courtroom during some phase or proceeding does not constitute an appearance. Footnote 193. Bullet point 2, domicile. The situs of the trust is in the United States of America, lowercase u, lowercase s, designating the, quote, the territory, end quote, the Union of States as the land of which the common law is supreme law, unless the trustee, in behalf of the trust, adopts a principal place in the, quote, other property, end quote, establishes a residence in a place subject to the federal jurisdiction with the, quote, intention to make it its domicile, end quote, footnote 194. Personal jurisdiction is lacking in this respect. It must purposefully establish an address directly in a revenue district, e.g. via post office box or street address, to be liable in this way. But if the trustee contracts with a private mail service provider or carrier, signing without prejudice, then personal jurisdiction does not attach. This affects an exclusion of any third-party intervener / overseer and reserves the obligation to the course of the common law of contracts, parentheses, i.e. bilateral contracts, not trilateral ones. Permission. It may seem tricky, but it is rather simple. Any answer to any presentment from a forum jurisdiction constitutes giving them permission to exercise authority, unless it is specifically a special or restricted appearance for the sole purpose of challenging their authority, parentheses, personal jurisdiction. If the trustee do not or does not, if the trustees do not answer in general or subordinate themselves, then consent has not been given. And if the trustee or trustees, presumably under proper limited liability, enter into a contract under a forum selection clause, then the forum selected will have personal jurisdiction. However, there are limitations to what constitute an enforceable forum clause. For if the clause is expressed in fine print, placed in the contract so as to avoid litigation, footnote 195, unreasonable or ambiguous, footnote 196, not, quote, fundamentally fair, end quote, footnote 197, or if the clause could not have been disputed without impunity as a part of a freely negotiated contract, then it is invalid. Minimum contacts. The trust must purposefully avail itself of benefits and services of the state, e.g., license, registering ownership there, contracting with the government there, availing itself of benefits and services of the legal system there, court actions, utilizing police or fire services, etc., systematically and continuously or sporadically, but substantially enough so as to warrant the trust or trustees being compelled to come into the forum, footnote 199. I will not get into diversity of citizenship here, though it is wholly important to subject matter jurisdiction in the federal courts, for it is highly improbable that it would even be necessary to bring it up in such an action, given all of the above with which the express trust is naturally armed. Footnote 200. As a final note, when the express trust is taking an action against an outside party, the most effective method is via the commercial process, i.e., a private, out-of-court legal action instituted under the fundamental rules of commerce, trade, business. Lawsuits should be regarded as a last resort to secure judicial enforcement of a private judgment, for public suits confer full personal jurisdiction upon the court. Taking a claim to a legislative court avails the trust of several benefits and services of that forum, and thereby establishes a substantial minimum contact. Even still, any action for judicial enforcement of a private judgment can be done out of court pursuant to the commercial process. In private actions, the maxims of commerce, the foundation of all commercial law and Western legal systems, govern. And there's some sample maxims here. We have first, a workman is worthy of his hire. This is expressed, supported by Exodus chapter 20, verse 15, Leviticus chapter 19, verse 13, Matthew chapter 10, verse 10, Luke chapter 10, verse 7, and 2 Timothy chapter 2, verse 6. The legal maxim is that it is against equity for freemen not to have the free disposal of their own property. All are equal under the law of God, moral and natural law. Exodus chapter 21, verses 23 through 25, Leviticus chapter 24, verses 17 through 21, Deuteronomy chapter 1, verse 17, and chapter 19, verse 21, Matthew chapter 22, verses 36 through 40, Luke chapter 10, verse 17, and Colossians chapter 3, verse 25. And the legal maxim reads, no one is above the law. Commerce by the law of nations ought to be common and not to be converted into a monopoly and the private gain of a few. In commerce, truth is sovereign. Exodus chapter 20, verse 16, Psalms chapter 117, verse 2, John chapter 8, verse 32, and 2 Corinthians chapter 13, verse 8. Legal maxim: to lie is to go against the mind. Oriental proverb: of all that is good, sublimity is supreme. Truth is expressed by means of an affidavit. Leviticus chapter 5, verses 4 through 5. Leviticus chapter 6, verses 3 through 5. Leviticus chapter 19, verses 11 through 13. Numbers chapter 30, verse 2. Matthew chapter 5, verse 33. and James chapter 5, verse 12. An unrebutted affidavit stands as truth in commerce. 1 Peter chapter 1, verse 25, Hebrews chapter 6, verses 13 through 15, and the legal maxim says, he who does not deny admits. An unrebutted affidavit becomes the judgment in commerce. Hebrews chapter 6, verses 16 through 17. Any proceeding in a court, tribunal, or arbitration forum consists of a contest or duel of affidavits wherein the points remaining unrebutted in the end stand as the truth and the matters to which the judgment of the law is applied. A matter must be expressed to be resolved. Hebrews chapter 4, verse 16. Philippians chapter 4, verse 6. And Ephesians chapter 6, verses 19 through 21. Legal maxim. He who fails to assert his rights has none. He who leaves the field of battle first loses by default. Book of Job and Matthew chapter 10, verse 22. Legal maxim. He who does not repel a wrong when he can occasions it. Sacrifice is the measure of credibility. One who is not damaged, put at risk, or willing to swear an oath on his commercial liability for the truth of his statements and legitimacy of his actions has no basis to assert claims or charges and forfeits all credibility and right to claim authority. Acts 7, Life and Death of Stephen. Legal maxim. He who bears the burden ought also to derive the benefit. And finally, a lien or claim can be satisfied only through rebuttal by counter affidavit, point for point, resolution by jury, or payment. Genesis chapter 2 and 3, Matthew chapter 4, and Revelations. Legal maxim. If the plaintiff does not prove his case, the defendant is absolved. And that brings us to the end of this section.